Welcome to Native America Calling. I'm Sean Spruce. A 25-year focus on taking on Indian law cases at the U.S. Supreme Court is paying off. That's the conclusion of the Tribal Supreme Court Project and report for the project's 25-year anniversary. Tribal legal cases have gone from 80% losses to a 70% success rate. We'll hear about that and two important cases involving sovereignty and jurisdiction in Oklahoma. That's coming up after the news.
This is National Native News. I'm Jill Freitas. A new state law requires language translation services for some government proceedings. The law does not take effect until July, but it already had a test during a hearing on a uranium drilling permit application. South Dakota Searchlight's Megan O'Brien explains.
The new law requires translation services for administrative contested cases, like a pending case involving a permit application for uranium exploration in the southern Black Hills. The State Board of Minerals and Environment is considering the drilling permit. Some project opponents requested Lakota interpretation services. Board members knew the new law won't take effect until July 1st, but decided to honor the intent of the law anyway. The first day of the hearing went without an interpreter. The board contracted with 2 interpreters for the following days. But some project opponents continued to object to the proceedings as conversations between lawyers and witnesses went without interpretation. On the third day, a project opponent filed a federal lawsuit against the board, the Department of Agriculture and Natural Resources, and the company seeking the permit. It cites concerns about the hearing's lack of interpretation on the first day. A spokesperson for the department told South Dakota Searchlight that the hearing is adjourned until the lawsuit is resolved. For National Native News, I'm Megan O'Brien.
Alaska Native leaders are remembering a longtime advocate for Inuit rights, James Jimmy Stotts, who passed away in May. As the Alaska Desk's Aliona Naiden reports, Stotts spent decades promoting food sovereignty and creating a unifying voice for Indigenous people across the Arctic.
James Jimmy Stotts died last month after a long fight with cancer. He was 78. For more than 4 decades, Stotts led the Inuit Circumpolar Council, an organization that represents Inuit people from Alaska, Canada, Greenland, and Russia. In his work, he fought for protecting Inuit sovereignty and culture and for including Inuit people in the decisions concerning the Arctic. Patsy Ahmet was Stotts' friend and former colleague.
He cared so much for our people all across the circumpolar north because we're related.
Stotts was born in Utqiagvik and lived in various villages across Alaska. Stotts worked for several tribal organizations, including the Arctic Slope Regional Corporation. Rex Rock Sr., the current leader of the corporation, called Stotts a mentor.
He was someone that I respected and you always looked up to, right?
The leadership of the Inuit Circumpolar Council Alaska said that Stotts worked to bring people across the Arctic together. Former Alaska politician and Northwest Arctic leader Reggie Jewell knew Stotts for a long time. He says Stotts was among leaders who made it their goal to educate others about the Inupiaq way of life.
And this is something that Jimmy understood really well. Rise to the challenge and responsibility.
Jewell and Ahmet say they hope Stotts' legacy lives on and the young people take on that mantle. In Anchorage, I am Aliona Naiden.
The San Carlos Apache Council has hired a forensic accounting firm to conduct an audit following recent allegations of embezzlement by the tribe's own staffers. KJZZ's Gabriel Pietrasio has more.
4 employees, including the tribe's secretary, have all been placed on paid administrative leave pending this review. The staffers have been accused of cashing fraudulent checks using the tribe's funeral assistance fund by creating hundreds of fake names for spouses or siblings who are not enrolled. The team responsible for overseeing the burial expense program paid out nearly $470,000 within the last 6 months alone. The tribe says it remains committed to ensuring that all funds are accurately accounted for. For National Native News, I'm Gabriel Pietrasio.
And I'm Jill Freitas.
National Native News is produced by Kawanak Broadcast Corporation with funding by the Corporation for Public Broadcasting.
Support by the Colorado Plateau Foundation, supporting Native-led initiatives protecting plateau lands, waters, and cultures by building networks, community, and organizational capacity. Grant proposals accepted through September 4th at coloradoplateaufoundation.org. Skugtash. For more than 40 years, Ramona Farms has revived ancient traditional foods, tepary beans, pinoli, polentas, and more, all from store.ramonafarms.com. Ramona Farms supports this show. Tongye.
Native Voice One, the Native American Radio Network.
This is Native America Calling. I'm Sean Spruce. Representatives from the 5 tribes in Oklahoma say the federal government owes them and about 10,000 other tribal citizens millions of dollars. They're pushing a class action lawsuit to recover oil and gas income and interest they say the federal government improperly withheld. We'll hear about that and another important legal case in Oklahoma this hour. But we're going to start off with a look at the legal wins and losses for tribal issues at the highest court in the land over the past 25 years. That's the time that the Tribal Supreme Court project has been active, prioritizing Indian law cases. The collaboration just put out a report assessing the success rate since its inception. We'll hear from our guest about those trends, and listeners, as always, can join this conversation too. Call us at 1-800-996-2848. What tribal sovereignty cases are you keeping an eye on? Let us know. That number again, 1-800-996-2848. We're also at 1-800-99-NATIVE. Joining us now from Boulder, Colorado is Melody McCoy. She is a senior staff attorney for the Native American Rights Fund, or NARF. She's also a citizen of the Cherokee Nation. Melody, good morning and welcome back to Native America Calling.
OCO, and good morning to you all, and thank you for this opportunity to be on your great show.
OCO to you as well, Melody. Now, we referenced this new report from the Tribal Supreme Court project. What are the numbers that stand out to you initially?
The numbers that stand out to me initially, and they're all in the report, are that when the project began in 2001, and it's turning 25 this year in 2026. Since that time, the United States Supreme Court has heard and decided 36 Indian law cases on the merits. So 36 cases in 25 years. Oddly enough, we've gone 2 terms, just the last 2 terms, without the court hearing an Indian law case. So 36 cases over 25 years. The other number, of course, is that the cases the court didn't hear. And so in 25 years, the project has monitored 550 cases. That's about 20, 25 per term of the court. And most of those the court doesn't hear. But that's pretty reflective of the court's high selectivity. But I think the big number you're probably looking for is that one of the biggest impetuses for the project was that in 2001, after 2 devastating losses in the court involving tribal jurisdiction over non-Indians who were on Indian reservations, at that time it was well documented that Native nations were losing 80% of our cases in the court. This was pretty much tracked from the 1970s and 80s and 1990s when there were a lot of cases in the court. But 80%, there was no worse group to go up to the court than American Indians or Alaskan Natives. Even criminal defendants had a better chance of prevailing in the United States Supreme Court. So that's what was the impetus for starting the Tribal Supreme Court project. We had to do something. And so in the last decade, we've gone to winning 70% of the cases. So that's a pretty good flip.
Yeah, that really is. Those are impressive numbers to behold right now. So what was the strategy to make the initial progress there, Melody? And how has that strategy evolved? Is here a 70% win rate is really impressive now.
It is, given the current court, which is difficult to many interests, and also is inclined often to rewrite areas of law that many people thought were settled. So the strategy from the start was to be coordinated and collective. So we got 575 federally recognized tribes, and most cases involve just one tribe or a few tribes, but the decisions of the court, the law, affect most tribes. So we really had to be coordinated and collective and as sharp as we could be with the court to try to educate the court, because the justices, even though federal Indian law is one of the oldest areas of the court's jurisprudence, it's still not an area of law that many of the justices are real familiar with. And to be honest, they for whatever reason, they don't seem to have a good grasp of the realities of many things in this country about the history of tribes and the laws. So it's really a great effort to educate the court when the court does take a case. And so we've merged federal Indian law experts with these days practitioners that are experts in just general Supreme Court practice. That's kind of the way that it works now. There's a group of attorneys who just really focus on Supreme Court cases, and the court kind of likes that. They tend to be attorneys who were Solicitor Generals of the United States or clerked for the Supreme Court justices, but they have a real expertise of being able to quickly, because you don't have a lot of time as your oral argument or even in your briefs, to get the court to focus on the issues and hopefully make good decisions. So we merged the expertise of federal Indian lawyers and these Supreme Court practitioners early on in the project. And then we also developed a robust amicus curiae, friend of the court strategy, because amicus briefs are a big part of U.S. Supreme Court practice. 90+% of civil cases in the court get amicus briefs filed, and those amicus briefs can be super helpful. The justices acknowledge that, and the advocates acknowledge that too. So we had to have a really, really focused, coordinated amicus strategy, and it's not quantity of amicus briefs, because the project has overseen cases with 1 to 20, but it's quality.
All right, quality. Melody, where do you go from here now? What is the long-term focus? I mean, 70% win rate, that's fantastic. But, I mean, are you shooting for a higher number than that? What's the end game?
Well, that's a good question. Of course, we want to maintain victories in the United States Supreme Court, and who knows whether we can maintain the percentage rate that we're at, but we've definitely improved it, and we don't want to see it dip back to losing 80%. That's for sure. The other thing that really we're focused on in the report is some initiatives for the next 25 years, and one of them is getting into these cases at the lower level, so that by the time the case gets to the U.S. Supreme Court, our arguments are honed and our strategies are developed, and our coordination and collective approach to this is well solidified. So getting involved in the cases in the lower courts before they get up to the Supreme Court is probably one of the number one goals.
And Melody, how do you do that? How do you keep an eye on these cases at the lower level that might need attention? Because it doesn't seem like they get that much publicity until they move up to the high court.
Well, far be it from me to comment on the mainstream media's reporting of Native issues, but no, you're right. So here's the thing, though. I mean, in this day and age of electronic platforms and services, we're tapping into the as best we can the highest level of most of these are you can use the free services, but if you pay, you get what you pay for. Some of these subscription services have a much better these days databases into federal, state, and even tribal court, lower court cases that we can start to research those and identify issues that we think are likely to rise to the level of the Supreme Court.
Melody McCoy kicking off our conversation here today on Native America Calling. She is a senior staff attorney for NARF, the Native American Rights Fund, out of Boulder, Colorado. And we're going to take a short break. We're going to come back, and we have other guests on the show as well. We're going to focus on legal issues today on Native America Calling. And the number to join our conversation is 1-800-996-2848. Tell us, what are your thoughts with regard to any impactful or high-profile cases involving Native issues that you might be paying attention to right now, specifically with regard to tribal sovereignty, cases that advance tribal sovereignty or protect and defend tribal sovereignty. Let's get some listeners involved in the conversation. Just pick up your phone and call us, 1-800-99-NATIVE. New rule changes in South Dakota are driving a 44% boost in the number of licensed Native foster homes. Progress comes as a new bill in Congress moves forward to improve funding for tribal child welfare programs. We'll track trends for Native foster youth on the next Native America Calling.
Trickster Cultural Center, an authentic first voice of Native American cultural arts, will host the 2026 All My Relations celebration, honoring diversity through Native drum and dance, artistry, resource exchanges, and vendor fair. Trickster Cultural Center's All My Relations celebration is open to everyone at no charge June 20th from 2 to 6 p.m. in Schaumburg, Illinois. More under events at tricksterculturalcenter.org or at 847-301-2090. Trickster Cultural Center supports this show.
Thank you for listening to Native America Calling. I'm Sean Spruce, and we're talking about recent legal cases that could be crucial to tribal sovereignty. Listeners can join the conversation by calling 1-800-996-2848. That number is also 1-800-99-NATIVE. We have Melody McCoy on the line in Boulder, Colorado. She's a senior staff attorney with NARF. And Melody, tell us more about the beginnings of the Tribal Supreme Court project. I know it began interestingly enough, on September 11th, 2001 in New York City.
Yes, thank you. Well, you got the first part right. It was definitely September 11th, 2001, and it was actually in Washington, D.C.
Okay.
There were there were four organizations close. There were right coast. There were four organizations: the Native American Rights Fund, the National Congress of American Indians, the National Indian Gaming Association, and the National Association of American Indian Court Judges Association, that called together tribe leaders, and they happened to pick that date. And, a lot of people showed up. There were hundreds of tribe leaders at a hotel in Washington, D.C., and the meeting started and was going well. And then, the towers were hit and the Pentagon was hit, and, chaos ensued. But partly because travel was restricted, the NCAI and NARF leaders, most people couldn't leave. They had nowhere to go because everything was shut down. So they urged, to get back to the meeting, and they said a prayer. NCAI called on a tribe leader to do a prayer for protection, and then the meeting resumed. And one of the biggest things on the agenda was to talk about strategies about how to better advocate as tribes before the United States Supreme Court, because a lot of Indian tribal issues go to the court, and we couldn't take this losing so many. So there was a model that was proposed to the tribe leaders about a decade before. In the last decade, in the 90s, the states, all 50 states and the District of Columbia, were facing the same issue. Their advocacy before the court was, not up to par, and it wasn't doing them well. So they established a dedicated state Supreme Court center, advocacy center. And this was proposed to tribes as a model because it was working. The states had improved their advocacy. And the tribe leaders were overwhelmingly convinced. So they set up a tribe leaders task force, and then a few months later, when things had kind of settled down from the terrorist attack, at the National Congress of American Indians annual convention in Spokane, Washington, NCAI approved the creation of the Tribal Supreme Court Project, directed the Native American Rights Fund to implement it, and the project began.
That is some inspiring history there, Melody. One more question before we move on to our another guest, because I know we have talked about the Tribal Supreme Court Project on this show before. And one of the goals as well is at some point to advocate for the first Native American Supreme Court justice, right? How's that coming along?
Slowly, but it's still a goal. We have more natives in the federal judiciary now than ever before. And most of them are at the lower court level. We still don't have a native on any U.S. federal appeals court. So that would be huge. We still need more natives to be law clerks at all levels of judiciary. So it's a big goal of NARF, NCAI, and the Native American Court National American Indian Court Judges Association, and the University of New Mexico's pre-law Summer Institute and American Indian Law Center. We've got more natives now as candidates, in various roles in the federal judiciary or in clerkships, but it's just it's a long-term goal, but it's a goal, and everybody's committed to it.
All right. Melody McCoy, Senior Staff Attorney with NARF, joining us on Native America Calling. 1-800-996-2848 is the number to join this conversation. And let's move on now to Oklahoma, where a big class action lawsuit is underway. And to discuss this, and joining us on Zoom from Washington, D.C., is Jeffrey Nelson. He's a partner of MCT Law and the manager of the Indian Law Practice Group. Jeffrey, hello. Welcome to Native America Calling.
Thank you so much.
And joining us from Oklahoma City, Oklahoma, are sisters Hazel James and Peggy Imotachi. They are plaintiffs in the case we're going to talk about here, and they are both Chickasaw. Hazel and Peggy, welcome to our show today. Hello.
Hello.
Great to have you both. Now, Jeffrey, I want to begin with you. You're representing tribal citizens, of course, in Oklahoma who contend the federal government withheld income from oil and gas development on their allotted lands. What's the basis of this argument?
Well, about 4 years ago, we were contacted by a Choctaw family, and they wanted us to look into the situation. They felt they were being cheated. They had an allotment owned by their great great grandfather, Noel Pope, and they knew that there was oil and gas activity there. But when they compared notes among the family members, they were seeing that some of the allotment owners were getting paid, but others were not. And then they would see like siblings who owned the same level of the undivided share in the allotment were getting checks for different amounts. So there were a lot of questions. They didn't know how to get answers. They went to the BIA, and the BIA was very, very unhelpful, especially with the five tribes under a special statute that Congress enacted. There's a different situation, and the BIA doesn't have as much responsibility. So the BIA would just point to the oil companies and say that it's not their problem. So this family wanted us to really look into it, and we did. We spent the next couple of years digging into this, and before too long, we decided, or we wondered, whether everybody within the jurisdictions of the five tribes was having the same issues. So we started to make some waves, and we got into the news, and pretty soon other families started to contact us, and they confirmed that, yeah, this is a problem that's happening all over eastern Oklahoma with members of all the five tribes. And that's why we started to look into a class action, and that's where Peggy and Hazel's family came in and said, hey, me too. Like, we've got an allotment at Chickasaw that is having some of the same issues. Like, we don't understand, how much money is coming in, or who's getting what, or what is supposed to be on these checks, because they come in straight from the oil companies and they don't have any sort of explanation. They don't have any equations or record keeping with them. It's just literally a check comes in the mail, $25, $30, no explanation.
Okay. Jeffrey, we're going to hear from Peggy and Hazel in just a moment, but I want to ask you, because we have listeners all over the country in different tribal communities, and there are listeners probably right now who get income from allotted lands, from oil leases or other types of natural resource extraction. And it's a pretty smooth process. Those revenues, those income streams go directly into an IIM account, individual Indian money account, that is managed by the Bureau of Trust Funds Administration. What happened here? Why didn't that process occur?
Well, we think it should have been the same for the five tribes, and there shouldn't be this problem. There is a statute that directs the Secretary of the Interior to establish those IIM accounts and to use them to gather up oil and gas lease money for Native Americans. There's one tribe that's excepted from that statute, and that's the Osage Nation, because they're treated separately. There's no exception built in for any of the five tribes. So when I read that statute, I'm thinking, why does the BIA and the Department of the Interior make an exception? And they say it's just because the leasing process is different. They taking a different stance. But we're going to fight that. We're going to ask the court to recognize that the five tribes should be treated the same way as everybody else.
And in your complaint that you filed, you mentioned the Cobell settlement and that you're seeking accounting from 2009 until the present. Why is Cobell so important in this timeline?
Well, in Cobell, there was a settlement that waived the claims for everyone who settled that, and now gets the benefit of that settlement. And so if you were to go back and try to assert claims that were like the Cobell claims at this time, you wouldn't get very far. The courts and the Department of Justice would recognize very quickly that those claims have been settled and waived. So we can pick up from the next day after the Cobell settlement. Cobell settlement was in 2009. So we're looking at leases that have been approved since that date.
All right. Thank you, Jeffrey. Let's hear now from the sisters Hazel James and Peggy Imotachi. And Peggy, you first. When did you first suspect you weren't being compensated for oil and gas production on your land?
Well, thank you guys for having me. I am Peggy Imotachi. I am a Chickasaw and Choctaw tribal member. And just to tell y'all a little about myself, I worked for Indian Health Service for 35 years and retired as a registered nurse there. And currently, I am the executor of my late husband, Dwight Imitachi's estate. And that's where things started popping in. And because, over the past several months, I've been working through probate, trying to understand royalty payments, leases, ownership records, estate assets connected to our family's allotted land. And what I've learned is that process can be very complicated for Native families, for any families, really. Records are spread across multiple agencies and oil companies, just like you say, or whatever kind of company it is. And it can be difficult to determine exactly what was produced, what was paid, and what still may be owed. For many of us, these payments are not just, numbers. It's so confusing. It really is because it affects everything, mostly financial security, but, we use that money to pay our bills, medical care, housing, things like that, and access to clear information to landowners and their heirs. We don't know what belongs to us. We don't know. It's so fractionated, and when we get reports from them, who can verify it? Even these, like I say, I wouldn't go to just call somebody out, but like the BIA, IIM, no one can give you a correct or a direct answer when you ask, well, you said you deposited $16,000 into my account, but I haven't seen a cent of it, and they can't even tell you where it is. But but this is how I really became interested in it. And one of Hazel's family members, her husband's family member, said, "Man, this sounds just like y'all. They seen us on Jeffrey on the news, and talking about this Choctaw case." And she said, "Boy, that sounds just like y'all." And so many other people that we know, because I started trying to compare records and started asking questions, and the more documents I reviewed, and the more I realized how difficult it is for ordinary families to track royalty payments and understand the information that we receive, and I feel like my hope is that the Native landowners gain greater transparency and easier access to information. I just kind of look at it like this: whether we find an error or not, every landowner should be able to clearly understand production, payments, ownership records without having to spend months searching for answers. And,
sure.
And I'm also representing my husband myself in his probate case. After I learned there's 45,000 pending probate cases across the United States, I said, "Oh my gosh!" And then, like you said, Chickasaw Nation has something different. I guess the BIA is a guardian over us. I had to go to court probably 6 months before my husband passed to become his guardian, because we can't make those kind of decisions or whatever, but there's a lot in it, and I just feel like this thing is bigger than any one family. There's people. There's elders, widows, veterans, heirs. All tribal citizens trying to understand their land and their royalties. But Thanks. I feel like transparency builds trust, and trust is something that every landowner deserves.
Thank you, Peggy. Hazel, how about you? When you first learned that it wasn't just you and your sister in this situation, but thousands of other Native landowners in Oklahoma, how did that make you feel?
I was really, I don't know, I guess it was more like awestruck that there would be that many people involved in something like this, especially when you're kind of focused on your own self and saying, this is not right, this is not right. So, yeah, very surprising.
And how hopeful are you that this lawsuit will be settled in your favor, and you and your sister and the other plaintiffs will be able to collect these lost revenues and the interest as well on those revenues?
Well, I am, I would be very happy, first of all. And then second, our family has had this original allotment since I guess Oklahoma became a state. And so it's like, I think I was like 27 before I really realized that we actually had an allotment. And trying to keep knowledgeable of that sometimes is really daunting because, like Peggy had said, the revenue that is taken out. And again, I would like, it's just confusing at times.
Yeah, it certainly sounds that way. Hazel James and Peggy Emotachi, sisters, joining us today on Native America Calling, along with attorney Jeffrey Nelson, talking about a big lawsuit there, about 10,000 tribal citizens impacted, arguing that the federal government owes them for lost oil lease income as well as interest. And we're going to take a short break. We'll come back. We'll chat a little bit more about this issue, and we're also going to talk with Jason Salzman, who's the press secretary for the Muscogee Creek Nation, about a Supreme Court ruling in Oklahoma that is in regard to an agreement between the city of Tulsa and the Muscogee Nation. So stay with us, listeners. We're going to continue this conversation on the other side of this break. And for those of you who would like to join the conversation, 1-800-996-2848. Give us a call. Phone lines are open.
Support from Davis Keelan Law Firm, a New Mexico firm standing with Native families suffering catastrophic loss. When tragedy strikes Indian country, Davis Keelan fights to restore stability, dignity, and justice, bringing a voice to Native families and communities for 20 years. More information, daviskeelan.com.
Kaufman & Associates has over 35 years of experience serving Indian country, supporting growth, transformation, and sustainability of tribal programs. More at kaufmaninc.com, KAUFFMANINC.com.
We're glad you're with us today on Native America Calling. I'm Sean Spruce, and we're talking about important legal cases that we are paying attention to right now. What issues about tribal sovereignty are you keeping an eye on? You can let us know by joining the conversation at 1-800-996-2848. That's also 1-800-99-NATIVE. We're talking about a class action lawsuit in Oklahoma, and we have attorney Jeffrey Nelson on the line, along with plaintiffs' sisters, Hazel James and Peggy Emotachi. And Jeffrey, this decision here that is going forward, could it set a precedent for future cases and arguments about oil and gas leases, one way or the other?
Not only oil and gas leases, but the federal trust duty in general. I think that everyone would agree that trust duty, we've seen an erosion of it in the past 20, 30 years. And this case, I think, tees up that issue pretty well. You have some 3,000 people who own shares of allotments and for whatever reason don't sign the oil and gas lease. They get nothing. They get no bonus payment, no royalty payment, nothing. And that's different than everywhere else in the country. If you're in Pawnee or if you're in anywhere else in Western Oklahoma or anywhere else in the country and you sign an oil and gas lease, or rather you don't sign the oil and gas lease, but your co-owners do, the BIA still ensures that you get a share of that royalty payment or that profit. Not so with the 5 tribes. If you don't sign the lease for whatever reason, you might not have ever even seen the lease, and you will not get paid. So how is it that the federal government is honoring the trust duty to those non-leasing owners when they let the lease get approved and the oil and gas company come in and take all the mineral resource from that allotment right out from under you, and you get nothing? That is a definite breach of the federal duty, of the federal trust duty in my mind.
What are the next steps, Jeffrey?
Well, we filed the complaint. The Department of Justice is on the other side, and they will no doubt file a motion to dismiss. That'll probably be, it's due in about 30 days, but they usually ask for an extension, so that'll probably be about 60 days. And then you go before the court and you have some briefing, you have a hearing, and you see if you have pled sufficiently to maintain your lawsuit. If not, then you can appeal. But if you do, then you go and you start your discovery, and you dig into and get the answers, get the documents, get the answers and the depositions, and start to uncover what's been going on.
Jeffrey, let's say someone's listening to the show right now and maybe they think they have interest in some of these allotted lands in Oklahoma that we're talking about today. Where can they go? How can they learn more?
Well, we have a website, mctlaw.com, and you can fill out a form to get a free consultation, and then we'll talk to you about your particular circumstance. And if you qualify as a member of the class that we are asserting, then we will sign you up and keep you informed. And at the end of the day, if there's a judgment or a settlement, like as in Cobell, there's a whole process where that gets distributed, and you could get some money.
All right. Thanks so much for joining our show today. 1-800-99-NATIVE. We still have the phone lines open for listeners who would like to join us. And let's go now to Okmulgee, Oklahoma, where we have Jason Salzman on the line. He is the press secretary for the Muscogee Creek Nation. He is also Muscogee, of course. He's been on the show many times. Jason, welcome back to Native America Calling.
It's Jay. Thank you for having me, Sean. It's always good to be back with you all and talking about important things that the Indian country needs to know. So
Absolutely.
Glad to be here this morning.
Well, glad you're taking the time, Jason. And let's talk about this Oklahoma Supreme Court ruling that an agreement between the city of Tulsa and the Muscogee Nation is not valid. What's unique about this agreement, Jason, and how is it important to the Muscogee Nation?
Well, back when we announced this agreement, Sean, combined with the city of Tulsa, we both praised it as being groundbreaking, being something that this is the way. When we have concurrent jurisdiction and reservations within cities, and in Tulsa's case, the second biggest city in Oklahoma, the biggest city maybe in the country that is entirely within reservation land. And so when we came to this agreement where they said, we're going to work with the nation, we're going to get the proper cases to the proper courts and authority, that agreement was seen as this is the way, not lawsuits. And we were taking we were suing the city of Tulsa at the time. That settled the lawsuit, and that was our way of saying this is the way. We got to get out of the courtroom, and we've got to get into the war room, where two organizations, a municipality and the nation, sovereign nation, are getting together and saying, we can hammer this out ourselves. We can work this out. We can work together. We can collaborate. We can communicate. And we can do this where we're not just paying a bunch of attorneys and a bunch of court fees and money going out the door that is desperately needed for our tribe, desperately needed for the city of Tulsa, for repairs, for services, for everything. And for us, the same. And we got all that money going to attorneys to fight in court? No, not anymore. This is the way. And the minute we do that, this governor, who has been a burr in our saddle for far too long now, cannot wait till he leaves, said, no, you got to get my permission first. You're trying to make this about race, and only certain races have to follow the law and everything like that, which is just complete idiocy. We are so sick of hearing that. We are so tired of hearing that, we can't have a state where the law is based on what your race is. Well, we're through trying to explain to this gentleman that nation citizens are not a race. We are a political status of citizens of a sovereign nation. So, you wouldn't subject the people of Paris, France to the laws of Muscogee, Oklahoma. Just the complete ignorance of that is something we've had a hard time getting this governor to understand. But I do understand, him wanting to get relief from the Oklahoma Supreme Court, because that's sort of like asking, if you steal something and asking your uncle to tell you that, it was okay that you stole instead of asking the proper authorities if it was okay if you stole. So him going to the Oklahoma Supreme Court is sort of like saying, this tribe, the tribes in general are really kicking my teeth in the courts. I've lost just about every court case with the tribes. So I've got to go to a court that will see it my way. And so we've sort of gotten a lot of trouble getting tribal and federal law to be upheld from the Oklahoma Supreme Court. And that's what happened here.
Okay. Jason, give us a little more background and some details on this agreement. Yeah. It had to do with who would be able to prosecute municipal violations against tribal citizens. Now, how did it benefit Muscogee Nation, and what was the cost? And I'm also interested just, in regular tribal citizens who find themselves facing a municipal violation. How did it impact them?
Yeah, well, and the agreement itself, Sean, we've seen a 20% dip in crime in the city of Tulsa since the agreement was come into place. We've seen it go down 20%. That's facts. So what the agreement basically did was it said it allowed certain municipal cases, mostly traffic violations, to be handled in Muscogee Nation courts. Now, not only does that what it does for the citizens is the people of the Muscogee Nation know that they will be adjudicated, prosecuted, whatever, ran through the justice system in their own court system, which is, I don't need to tell everybody that's listening why that's meaningful and why that's a preference for people, not to get easier or more lenient, whatever, but just you're a part of that nation. We are a nation within a state. And so it was important for our people to know that not only that, but strengthening the promise that was affirmed in the McGirt decision in 2020, where, we go back to the fact that a federal court said, this is the law. We don't care if it's inconvenient. We don't care if a state has been doing it for 100 years this way. This is the law. And unless Congress explicitly states that it is no longer a reservation where that nation doesn't have adjudication powers over their territory and their boundaries, then it is what it is. It's what it says in the law still. And I would challenge people out there listening to go. A wonderful article appeared in the Tulsa World. You can Google it. May 14th. May 14th is when this appeared in the Tulsa World on a similar case we had with the city of Henrietta here in Oklahoma that wanted to challenge this as well. And here's what the federal court judge said in his decision to uphold the law for us, for the Muscogee Nation, saying, no, the city of Henrietta is wrong here. He says, this case does not require the court to break new ground. It requires the court to hold the line. This order does not create new law. It enforces old promises. It reaffirms what within the geographical boundaries of the Creek Reservation, the Constitution, federal statutes, and treaties govern jurisdiction, not municipal preference, not state expedience, and not political convenience. And that's what we have here with this Oklahoma Supreme Court ruling for the governor, is political convenience, state expedience, and municipal preference, not for the city of Tulsa, but for what they see. So they see it as, the mayor, he had a problem with the mayor on this politically. He said the mayor shouldn't be able to get into this agreement with the Creek Nation without asking me first. And so this ruling, similar ruling in Henrietta, the decision, and I'm not just saying this because I let's say I'm not even a citizen of the Muscogee Nation. I'm not the press secretary here. This is beautifully written on, and it's just a perfect example of why nation business is federal business, not state business. So with him saying, it reaffirms that within the geographic boundaries of the reservation, the Constitution and federal statutes and treaties are what govern jurisdiction. This shouldn't even been going before this Oklahoma Supreme Court. If we have a problem, and it's in federal court like it was with the Henrietta case, then the federal court knows that when it comes to these matters, it's Constitution, federal statute, and treaties.
Jason, how big a challenge is this to the McGirt decision?
I don't think, Sean, that this is at all a big challenge to the McGirt decision. I think this is a little blip on the road that lets the governor get a small political victory, and he can do a little football spike on his way out of the office. I really don't think we're continuing to work with the city of Tulsa. We're going to go back to state tribal committee where we have great relationships with our legislative partners in Oklahoma, and we're going to get this approved. And for us, it's business as usual here. We're continuing to lower crime in the city of Tulsa. We're continuing to do it all around the reservation. We now have a Department of Public Safety that is building a fire division. It has the most cross-deputization agreements with local law enforcement agencies we've ever had. We are doing the work. We're doing it the way it's supposed to be done. We're not going to let this small, like I said, this political convenience for the other side slow us down or stop us. We're doing great things here, and these are things that are just meant to sort of kind of get in our way and make us, like I said, and while I appreciate today's topic for the show, it's just fodder for everybody to talk about and everything like that. At the end of the day, this isn't going to roll back McGirt one bit, and it's not going to stop the progress and the momentum we've created with the city of Tulsa with this momentous and historic agreement. We're going to keep going.
Jason, under the agreement, the city said it would not prosecute municipal violations against tribal citizens, but it would still enforce those laws. Prosecutions were to take place in tribal courts. What are you hearing from any tribal citizens that have these municipal violations that they're having to deal with? Is there any confusion with regard to where those cases will be heard?
Anytime we're in the middle of a jurisdictional shift like we are, even 6 years later, there is challenges, whether it be technical, procedural, whatever the case may be. And in our case, we just needed to take a few years to just build capacity. Because when McGirt hit, it wasn't, hey, McGirt's going to hit in 3 years, you got time to build. It was McGirt hits right now. So we had to do all sorts of things, like temporary court facilities. We had like trailers here on headquarters just while we're building our brand new court system, which is over halfway through with construction. Love to have you guys down when we cut the ribbon on that thing. It's going to be a big day. And but we had to do a lot of things to sort of build capacity. So there's always been sort of barriers and things and everything like that. But another part of our movement was an education to the public and our citizens about this is what this means. Just know your rights, present, don't be, adversarial or anything. If you're stopped by a non-tribal police force, we have all kinds of cross-deputization agreements. So when they stop you and we have that cross-deputization agreement, they might as well be light horse because you're a tribal citizen. So remain calm, remain respectful, show your tribal identification. It will be verified with our citizenship office, and then once it is, you will go to the right court. That doesn't change anything on the street. There'll still be arrest if there needs to be made or a citation or whatever. It's simply that relax and know that at the end of this, you will be in the right court. So I think for a lot of them at first, there may be some, struggle or maybe some misinformation out there that we faced a very big social media campaign, public services campaign from the state on this is bad for you, this is awful, they're going to open the gates of the jails and let everybody out, and it's created chaos in the state. Well, now that we're 6 years down the road, people have been able to live long enough to see that was not true. And so it makes it a little easier for us to say, hey, they're just trying to swim in your head and get anxiety a little bit up amongst our tribal citizens. Just relax. Everything's in control. And when we get big-time partners like Mayor Nichols and the city of Tulsa gathering together with us to sign these historic agreements, it just makes our job that much easier. We certainly appreciate them. And like I said, We're not going to let this little bump in the road stop us or curb the momentum.
Jason, thanks for coming on the show today. Really appreciate you.
You bet, Sean. Always a pleasure. Thanks, buddy.
And with that, we are out of time. So I want to thank all of our guests who joined us: Jason Salzman, Melody McCoy, Jeffrey Nelson, Hazel James, and Peggy Imotachi. Please, listeners, don't forget to tune in again tomorrow. We'll have a discussion about trends in foster care in Native communities. I'm Sean Spruce. You've been listening to the one, the only Native America Calling. Enjoy the rest of your day.
Grand Canyon Conservancy fosters visitor engagement with the landscape through learning, discovery, and stewardship. The Grand Canyon Conservancy Field Institute provides immersive and educational adventures designed in partnership with Grand Canyon National Park, including day hikes for the family, once-in-a-lifetime backpacking trips, and art classes with expert instructors. More at grandcanyon.org. Grand Canyon Conservancy supports this show. Who protects Indian country? Amerind does. As the only 100% tribally owned insurance carrier, Amerind helps strengthen tribal communities by providing reliable insurance coverage and keeping dollars in Indian country. From property and liability to commercial auto and tribal workers' compensation, Amerind is here to protect what matters. Celebrating 40 years of serving Indian country. Learn more at amerind.com. That's AMERIND.com.
Native America Calling is produced in the Annenberg National Native Voice Studios in Albuquerque, New Mexico by Koahnic Broadcast Corporation, a Native nonprofit media organization. Funding is provided by the Corporation for Public Broadcasting with support from the Public Radio Satellite Service. Music is by Brent Michael Davids. Native Voice One, the Native American Radio Network.